Back in June, as part of a simplification of the rules governing attorney advertising, the state courts relaxed restrictions on the ability of lawyers to solicit new clients, specifically removing a restriction on when they could pitch clients following an incident that might be the crux of a new case. For more on the update, we're joined by New York State Bar Association President Taya Grays. Welcome back to the show.
Thank you so much. Happy to be here.
Well, let's begin with the premise that the state has rules, historically lengthy rules, governing attorney advertising and solicitation. What is the court system's interest in regulating what might be a standard, unregulated practice in pretty much any other business?
Well, let's start from the broader picture, Dave. Our court systems are the ones responsible for licensing and as it relates to kind of generally professional ethics with the bar, right? We have a grievance system that's set up by departments, and then we have the court that puts together these rules. So in other jurisdictions, the bar associations would do that. They're mandatory bar associations, but we're not a mandatory bar, we're a voluntary bar. And so we work with the unified court system when these rules are being promulgated. So that's big picture as to kind of the why, right? Because people may be wondering, well, why are the courts doing this? Why aren't the lawyers doing it themselves? So let's start off there, right? That's how it's set up from a licensing perspective and the regulatory aspect of it. So then more specifically, why rules? Well, why are there rules for anything, right? Rules serve a few purposes. One, it's how do you do what you're supposed to do, right? People have to understand why they do what they do, how they're supposed to do what they're doing. Are there time frames? Are there requirements? And so rules in this instance allows lawyers, all lawyers, to know what they need to do as it relates to professional ethics, right? What's the code of conduct? What are the right things you're supposed to do in order to make sure that you are doing your job, that the administration of justice is fair, right? Because we're a part of that, and also making sure that we're doing right by our clients, right? So these rules help everyone to understand, what are you supposed to do? What's the right thing to do? What are the things that advance justice and make sure that our clients are protected, but also that we're protected, that we know what we're supposed to be doing. So that's next picture, right? Sort of second level down. Rules as it relates to advertising. That's your specific question, right? Why does it relate to?
Yeah, we don't have rules for wedding photographers and what they can, put out there.
Yeah, well, wedding photographers aren't licensed. We are. Doctors are licensed.
Give the Department of State enough time, and we might be licensing them pretty soon in New York.
Well, we hope not. But because of the special responsibility as lawyers that we have, and there's a trust, right, that we are going to do the appropriate thing. Mm-hmm. So to make sure that lawyers do that, and going along with the broader point of why do we have rules generally, these particular rules, as we've seen, these rules are a little outdated, and the removal of this 30-day ban is a part of the modernization effort. But historically, if we take a step back over 100 years or so, it was a bit unseemly for lawyers to advertise. And so there were a lot of rules around lawyers couldn't advertise at all. But as things have changed, like the reality has changed of what our practice is, how dispersed people are, and the ways of people getting information has changed. When the country was a lot smaller, it was easy to go to your next door neighbor and say, hey, do you know a lawyer, right? Someone that you can vouch for that will do right by me. But our communities are very large. Not a lot of people have come in contact with lawyers. And so advertising is a very important way for lawyers to be able to communicate to people who need to have services. So after the people realized, maybe advertising is a good thing, then they made some changes to a lot of regulations around it because it was still considered, lawyers shouldn't be doing this, but we recognize that lawyers have to. But as things have progressed so much with the internet, TV, radio, people have so many more means of being able to get information. These rules around advertising have become even more outdated. And there have been trends in many states, about 20 plus states, that have been looking more closely at these advertising rules and making changes to make them more streamlined and more efficient so that the lawyers have a better understanding and a clearer and simpler understanding of what they're supposed to be doing.
Well, one of those substantive impacts, though, is that restriction that currently exists on soliciting clients within 30 days of an incident. And I'm curious about the practical effect of that because just in my commute alone, I saw multiple billboards encouraging people to contact XYZ firms. So how is that different than a specific solicitation for someone involved directly in an incident? I mean, does it have a practical effect?
Well, and let's start off with what the rule was, right? So the rule under the New York Rules of Professional Conduct, it was Rule 7.3E. This is what's changed. There was no solicitation relating to a specific incident involving potential claims for personal injury or wrongful death. It shouldn't be disseminated before the 30th day after the date of the incident. Then there was another provision that said if a filing needed to be done within 30 days of the incident itself, no unsolicited communication shall be made before the 15th day after the date of the incident. So that's the rule that is changed. And it's very specific. This is if you're involved like in a personal injury or wrongful death matter. The advertising you're seeing is probably a lot more general than that.
Well, that's what I
right?
mean. You mentioned specific incident,
Yeah.
but I know if I have an accident or
Yeah.
I get rear-ended, I'm going to think about that ad that I already saw. And while it wasn't specifically tailored to the incident that
Right.
I am experiencing, there already was advertising that's influenced me. So that's why I was curious what you see as the practical effect of relaxing a restriction on specific incidents, since there's already so much general advertising.
Well, the general advertising is general, right? This is something that would be a bit more targeted. So it allows attorneys who may have some information or have come in contact with individuals who may need someone. Now they can directly say, well, hey, if you do need my services, this is what you can do. This is how I can help. So that specific restriction around that direct solicitation with someone, in contrast to the more general one, that's what's been changed. So the lawyers can be more, they can reach out.
Yeah, what
where they
does
couldn't
that
do
look
before.
like in 2026 and beyond? I mean, are we
Yeah.
going to have online social media ads that are tailored to people who have searched, I was in a car crash and how do I pay my bills?
Well, I don't know what it's going to look like. I mean, there, as you just identified, there are many channels in
That's
which
what I would do
lawyers.
if I was trying to find people.
Well, even though that could be a way, there still are rules, right? Go back to the rules. This 30-day time period has been removed. But that doesn't mean that the way that lawyers do outreach is not still, there's still rules around that, right? So some of the things that still remain prohibitive, and this kind of goes back to a piece about what we're talking about. Because I think you're saying, well, can't they just go out and use all these different channels, right?
Sure.
And bombard people with information. No, they cannot do that. So one, they can't make false and misleading statements. Two, they can't use coercion, duress, or harassment. And some people may think, getting tons of emails from someone is a form of harassment. So this would manage that, right? You can't inundate people with information. You have to be more judicious in how you do outreach. You can do the outreach, but you have to be careful about how you do it. Lawyers still may not continue to solicit someone who's made it clear they don't want to be solicited, right? So if you say, no, I don't want you, then they can't keep going and, they can't DM you, right? And say, hey, what about me? And then lawyers still face restrictions on live person-to-person solicitations when the lawyer's financial interest is a significant motive for them doing outreach. This still has to be, I'm trying to assist you and give you information about services that are available. So these areas still provide some guardrails in how individuals can be contacted, and it still protects them because what the lawyer is giving is truthful information, targeted information. They're not going to inundate you with tons of stuff and be on many channels. They have to be more judicious in how they do the outreach to say, hey, I can help you.
Well, before we move on, let me reintroduce you for listeners just joining us. This is WCNY's The Capitol Press Room, and I'm speaking with New York State Bar Association President Taya Grays about updated to the advertising and soliciting rules and regulations for New York attorneys. Can we have literal ambulance chasers now under these new rules?
So ambulance chasers are what? People that follow the ambulance and they're like, hey, me, hey, me, hey, me.
But it's more of a metaphor. I'm curious now, could we have a literal one?
Well, getting to that point, I would say no,
Okay.
right? Because if someone does follow the ambulance and goes to the hospital, that person could be like, if someone's asking you and you're like, I just had a concussion, I don't know what's happening, and they're asking you questions, that could be considered coercion, right? You're not in your right frame of mind to be able to make a decision. Or it could be seen as you're asking, like the lawyer's trying to have someone make a decision under duress. right? So there still are these rules, like I said, that would prevent that type of behavior. So do they go to the hospital? Maybe, but they have to be mindful that if they take certain steps in talking to someone whose mental state of mind is not one in which they can make a decision, they could still fall under a complaint or still have a complaint filed against them for coercing someone or acting or trying to get someone to do something under duress.
And how does the individual benefit from ending these restrictions in terms of the timeliness of these? How does that individual benefit from potentially getting an attorney faster if someone's reaching out to them proactively?
So the prohibition, this time period, was for plaintiff's attorneys. If you worked if you're in an insurance company, the insurance company could still do outreach to you and ask you to settle a matter. There was data that showed the insurance companies were actually more at an advantage, right? Because they could go and say, hey, I know you're in pain. I know you want to get this over with. Let's just settle this matter, right? And an individual who's like, well, I don't know, a lawyer can't speak to me during this time period.
But they could reach out to a lawyer.
If they were aware of the right lawyer to go to.
I think if you've watched enough TV or seen any ads, you know that you could hire a lawyer. You know that you don't have to go in to these conversations unarmed.
That is true. But if someone's calling you, it's your insurance company, and they're saying, we can give you something right now, someone may not feel as inclined to get legal services, or they may say, well, my insurance company is going to handle this, right? So I think for most people, they want to do what's easy, right? If they just went through something pretty horrible, an accident, they're out of work, they're healing, and the insurance company's like, we can take care of this for you, right? They probably aren't thinking about a lawyer, even notwithstanding that there are lots of ads all around, right? I'll say this as an example. It's in the criminal space, but I think it's an indication of people's mindsets. When I was a prosecutor, it was amazing how many people would talk to me, right? I would sit and have conversations with them. You watch lots of TV, and what do they say? Don't talk to police. Don't talk to prosecutors. You have a right to remain silent. I can't tell you how many people actually ended up saying things to me, and sometimes it was incriminating. And I'm like, oh, I've told you, you have a right to remain silent. You have a right to an attorney, and they still want to speak, right? People may know that sitting here, right? There's no exigent circumstances. You're not in pain. You're in your normal mindset, right? But when you're under pressure, right? When you're trying to think about what am I going to do about my job, right? I have these bills that are coming. The hospital is asking me about stuff. You may not be thinking about a lawyer. You're thinking about what's in front of you, and someone is giving you an option to resolve that. You might just say, look, I'm just going to take it. But this allows attorneys to do some outreach to let people know, hey, you don't have to make that decision right away. You can wait, and I can help you think through what's the best way for you to be able to be remunerated for what has happened to you.
You mentioned that there are restrictions on what an attorney can say in terms of false and misleading statements. My understanding, though, is that as part of this effort to streamline, to cut out hundreds of words from the rules and regulations, that this is going to include language about prior results not guaranteeing similar outcomes. Is that correct, or is that sort of caveat at the end of advertisements going to be going the way of the dodo, so to speak? Is that going to be required anymore?
The rule change, as I understand it, isn't going to impact that.
So they still have to say prior results are not indicative of future performances?
Yes, and it's true. It is true. If they said something different, that would be false and misleading.
And if by taking it out, though, maybe people don't have an expectation, but you're saying it's going to be in there. People will still have to say, don't just because I got $1 million for this guy, it doesn't mean I'll get $1 million for you.
Correct.
So to speak.
Correct.
Interesting. What's next for the implementation of these rules?
Well, my understanding is now that let me say something before I get to that. The state bar has already provided some comment on this. Our Committee on Standards on Attorney Conduct, we regularly review the professional conduct rules, and in 2020 we reviewed this and we provided some comments to the Office of Court Administration. And then more recently, at the end of last year, when there was conversations around this rule being removed, we submitted them again, just to remind the court that we've already provided you with some insights into this and why we think there should be a change. I mean, for the reasons that we've discussed, right? It's more about advancing consumer protection. It is in support of our members, from the trial bar to even the playing field against the insurance companies. And also, the ABA, and in addition to those 20 states that I identified, had made recommendations. They changed their rules, and so we wanted to make sure that we were in alignment and not putting our lawyers at a disadvantage, which goes back to the second reason, why we put this forth. So we've already provided the commentary. There had been a comment period prior, and so my understanding is that this moves forward. Now, there's probably some internal implementation work that needs to be done, right? It has to be put up in the rules. There's probably a time period for that. But as soon as the administrative components of it are taken care of, then it should be effective. There might be some additional implementation rules as well, but aside from that administrative component, I'm not aware of any other next steps that need to be taken before the rule goes into effect.
And in terms of policing this changing landscape moving forward, do you feel like the status quo works? Do you feel like there is enough of a checks and balance in the system to ensure that people will be reported if they are being too aggressive with their outreach or maybe violating existing standards like false and misleading statements? Is there reason to think that there are enough eyeballs that are actively policing this?
Well, we do have, as you said, that there's so many advertisements about lawyers, right? And I think as part of some of the advertisement, people are aware that they should be mindful of when people are doing the right thing and not doing the right thing, right? And so I think as a part of that general understanding, people are aware that they can go and complain, right? There's somebody that they know they can go and complain to if they feel a lawyer isn't doing the right thing. Now, they may not know specifically where to go to, but I think the infrastructure that we have in place, our grievance committees that are set up by department, they get lots of complaints from people. And so I think there's an understanding that even though they may not know specifically where in the courts they can go and complain, that they can go online, like you said, right? Go online and figure out,
Google's
right?
Google's helpful here. Yeah.
Right. Lawyers harassing me. Where do I go? So I think if people feel that a lawyer has stepped out of bounds, that they will be able to find, going online, they'll be able to find the infrastructure that we currently have in place, that mechanism for enforcement to make sure that we're holding lawyers accountable under the new set of rules.
Well, unfortunately, that's all the time we have for this conversation. We've been speaking with New York State Bar Association President Taya Grays. President Grays, thank you so much for making the time. Really appreciate it.
You are welcome, Dave. So happy that I'm back and you asked me these questions about this. So take care.
Support for the Capitol Press Room comes from O'Donnell & Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.